there's another provision in the law that a lot of people talk about and highlight as being, something, new and revolutionary and really, really great, and it's referred to as portability. Typically, when you have a client and they do their estate plan, as part of that estate plan, either in their will or their revocable living trust, they'll set up what's known as an A-B trust arrangement. And the A trust and the B trust go by different names. Some folks call the A trust the survivor's trust or the marital trust, and some attorneys call the B trust a bypass trust or a credit shelter trust. So you'll see different attorneys using different names for them. But the reason that those are in the document is so that we can take advantage of both the husband's and the wife's exemption. And if you don't have the assets distributed roughly equally between them, or you don't make sure that the spouse that has less assets has at least $5 million, it's possible that they could lose part of one of the spouse's exemption. Very common draft for a will is, I love you, honey, and I'm going to give you everything. So everything goes to the spouse, and nothing goes into the B trust or bypass trust. And in that case, what happens is we haven't taken advantage of the first spouses to die their exemption, because everything passes to the spouse, and now we only have the surviving spouse's exemption to shelter those assets. And so you'd have folks that either had done an I love you will and hadn't taken advantage of the ability to create a bypass trust, or you could have folks that hadn't divided the assets equally, and the poorer spouse, the spouse with less assets, died first, so you wouldn't be able to take full advantage of their exemption. Or you could have folks that just didn't do any planning at all, didn't have a will, didn't have a trust, and again, we wouldn't take advantage of the exemption of the first spouse to die, and that would end up costing people hundreds of thousands of dollars in extra taxes. Could be $300,000 or $400,000. Now with a $5 million exemption, it would be, in the $1 million range. What portability allows the surviving spouse to do is to use whatever portion of that exemption the first spouse to die didn't use, and that's all portability is. We've made this exemption portable between the first spouse to die and the second spouse. And it's a really good thing that Congress has done, and it's going to save some folks that haven't planned or haven't planned well, haven't divided their assets, well between them, or haven't put a bypass trust document or language in their will or their revocable living trust. It'll be good for those folks in most cases. But there are some drawbacks to this portability provision, and one of the major ones is that, typically the first spouse will die, and you'll put $1 million or several $1 million into the bypass trust, and that will grow, and that could easily quadruple from $1 million to $4 million before the surviving spouse died. If we rely on portability, what's excluded is only the $1 million, not the growth on the $1 million. If we use the B trust, not only is the $1 million excluded, but the growth is. So we could have as much as, say, $4 million in that B trust, the bypass trust, and it would be subject to tax when the surviving spouse died. So portability is good. It helps people that haven't planned, but it's not the best way. The best way to do the planning is to, have the attorney draft so we have the possibility of creating a bypass trust, fully funding it, and moving all the appreciation out of the estate. Unless Congress acts, then we're going to go, on 1/1 of 2013, we're going to go all the way back to only $1 million exemption and a top tax rate of 55%. So the estate tax exemption will go from 5 to 1 million, and the top tax rate will go from 35% all the way up to 55%. And so, there's, a lot of your clients will be thinking, hey, I don't have $10 million, I don't have to do any planning, and that's really the wrong answer. Unless the client can promise you that they're going to die within the next 2 years, they need to plan as though it could be as bad as $1 million exemption. Now, again, we hope that Congress will do something, maybe toward the end of 2012, or if not then, maybe early in 2013, to prevent us from having that $1 million exemption and giving everybody something higher than that. But there's a very good chance that it's not going to go all the way back up to $5 million. It's not going to, the top tax rate's not going to go all the way down to as low as 35%. And so clients still need to plan. And once again, they may have set up a life insurance trust. They may have life insurance in that trust. They might be thinking, well, maybe I don't need the life insurance. And again, they've set up a good plan. Life insurance is a good asset to have in that trust. I would just recommend to them that they just sit tight and take it easy and wait to see what Congress does before they make any rash and irrevocable moves with respect to the life insurance or the life insurance trust or other estate planning that they've put in place. Issues caused by the new estate tax law. Even though almost all of the news is good, there's some situations that they may want to discuss with their attorney. One of them is that the formula clause in their will may not work the way that they originally planned for it to work. They may have written their will when the exemption was only $1 million or $2 million, and that's all that would go into the B trust. However, the language they use may say, we're going to put the maximum amount. Whatever the maximum amount is, it's going into the B trust. So they could end up with as much as $5 million in the B trust, even though they never intended that. And that can cause a couple of problems. Number one, if all of the estates or most of the assets in the estate goes into the B trust, that may leave little or nothing for the surviving spouse. And so you'd have to look at the language in the B trust to see if it was primarily set up to take care of the spouse or primarily set up to take care of the children. And this can be a particularly important issue in a second marriage situation where very often the B trust is set up primarily for the benefit of the children from the first marriage. And if that's a situation that any of your clients have, they need to talk to their attorney to see what their trust says to make sure that the spouse as well as the children are taken care of and that what the client really wants to have happen is going to happen. And while the federal law has moved the exemption all the way up to $5 million, I don't know of any state that has followed suit. And so you could have an estate that's free from federal estate taxes, but you may actually trigger a state inheritance tax, and you might trigger it earlier than is necessary if you don't talk once again to the attorney and kind of coordinate this plan to see how it works on both a federal and a state level. The next thing, negative in the law is, it doesn't give us long-term certainty. It's only 2 years. So, the best the client can do with any certainty is plan for the next 2 years. Another thing they might want to talk to their attorney about is, does it really make more sense to use a B trust rather than hoping that this provision of portability is A, still in the tax law when I die, because it's only there for 2 years, and that it's really, that's the better way to go than using the bypass trust. And I think most attorneys are going to elect to have a B trust or bypass trust as part of the planning document. Looking at the state-to-state taxes, some of the exemptions are fairly low. You can see New Jersey here is $675,000. Some of them are in the $1 million range. Some of them are a little bit higher than that. But the taxes are not insignificant. In Washington, they could, in Washington State, they could be up to 19%. Connecticut, 12%. There's some double-digit. A lot of states have double-digit top tax rates, and rather than paying those at the first death, if they work with their attorney, they may be able to defer those until the second death. Now we're going to kind of turn from, what does the law say to, well, how can we use this as part of our planning for our clients? There's a whole lot of opportunities here. We're going to list those on the next couple of slides. And, we want to make sure that our clients are aware of the potential opportunities and that in these next 2 years they decide which ones they want to take advantage of. One advantage or one planning opportunity is tax rates are fairly low now, comparatively speaking, certainly to what they will be in 2013. And clients can still do a Roth conversion, and the formerly they were limited to doing a Roth conversion only if their income was under 100,000. Now, just like it was last year, you can do a Roth conversion and your income doesn't come into play. And so, Roth conversion is still on the table as a possibility. Another, possible planning suggestion for your clients is that 2% payroll tax that you don't have to pay anymore, and you've seen your take-home pay go up by that 2% each year. Well, you could use that to increase the amount that you're putting into your qualified plan. So instead of just spending it, you can save it and you can put into a qualified plan. Capital gains could go up to 20% in 2013, and so perhaps at the end of 2012, after we've given it some thought over the next 18 months or so, at the end of 2012, if Congress hasn't acted, maybe we want to take some of our capital gains at that point to lock in the 15% tax. Obviously, if you can give away $5 million, where, for the entire history of the gift tax, it had always been $1 million or less, you can give away $500,000 for your high net worth clients. That's something that they really have to consider doing in these next 2 years. And again, we don't know if the answer is they should do it or they shouldn't. That's going to the ball's going to kind of come into our court to do the cash flow analysis to figure out if they can afford it. But if we can conclude that they can afford it, and then that's not going to cause them to lose sleep at night, then we're going to recommend to them that they move as much as that $5 million as they can. Again, if one of your clients who's 70 or older wants to make up to $100,000 contribution to charity, they can tap into their IRA to do that. If a client has some stock options that they want to that they're thinking about exercising, right now the AMT is patched, the alternative minimum tax is patched, and so this would be potentially this year or next year would be a good time to do that. A lot of parents have loaned money to their kids, and they weren't really all that adamant about the kids getting paying them back. Kids have to pay them interest, but they might not pay the principal. That might have just been outstanding until mom and dad died. Well, now with a $5 million exemption, mom and dad could forgive those loans if they wanted to. A lot of parents have made loans to their kids for a lot of good reasons. Education, start a business, but one very popular reason is so that the kids can buy a house, and very often it's so that the kids can buy a house that's close enough to mom and dad so they can visit the grandchildren. And again, if there's a loan outstanding and the kids have been paying interest on it and mom and dad can afford it, one of the things they could do with that $5 million exemption is they could forgive some of those loans. Also, there's some accelerated depreciation provisions in the new tax law for businesses, and again, they can talk to their CPA about whether or not they're going to be able to take advantage of those if they're business owners. Okay, here's some strategies that might save some money on income taxes. This is kind of an agenda slide for the next 5 or 6 slides. Life insurance can be a very good asset to own because it has some very favorable tax treatment. It grows tax deferred. You can access the money by loan and withdrawal without paying income tax, so you can get money out of the policy income tax free, and the death benefit is income tax free. So life insurance has kind of triple tax advantages, and because of that, for clients whose income is so large that they can't do a Roth, they've kind of maxed out on their Roth. The life insurance can function pretty much like a Roth without any maximum contribution limitations. It can provide them some favorable, tax-favored income in retirement, and we often use it as part of an incentive plan for key employees. And you can use a whole life policy for clients that are risk adverse, cash value whole life policy, or you could use a variable universal life policy for clients who still want to be in the market. And we've already talked a little bit about some of the tax advantages of the life insurance contract.